started. So there's a real appetite for this topic because these rules come out today. And we probably should have tried to do this before today. But at least we can get some information from an expert in Helen-Anne MacAlister. So just tell you a little bit about Helen-Anne. Helen-Anne's a senior legal consultant, employment and commercial for Source Workplace, the legal arm of a professional services business. Helen-Anne specialises in employment law and industrial relations and has over 15 years of legal experience gained in corporates and in private practice at law firms. She regularly advises C-suite and senior managers on employment-related corporate risks, governance and compliance. Helen-Anne was previously General Counsel for a global labour hire organisation and continues to advise other labour-intensive industries. She has substantial experience dealing with complex employment relationships, along with other more common employment issues and disputes. Helen-Anne's experience means she is adept at creating commercially acceptable outcomes. Helen-Anne provides clients with grounded, practical and commercially focused advice. So what we're going to do today, everybody, Helen-Anne's going to present, sharing her screen, as you can see, and she's going to present what you need to be aware of with this new legislation. And please put questions in the chat if you have them, and we can answer as many as we can. But hopefully Helen-Anne will make this a bit clearer. I personally find this very confusing. So let's get started. I'll hand over to Helen-Anne.
Thanks very much, Elizabeth. You did quite well in that introduction, considering you've got COVID.
Thank you.
Well, listen, before I start, I was actually just going to give you, which you've just given a brief overview about what Source does, Source Workplace, Source Services. So I guess, in essence, we act as in-house lawyers for companies. So if you're engaged as if you engage an in-house lawyer with your business, and that's exactly what we would do. We provide all the services that an in-house lawyer would provide to your own organisation. We are frequently engaged as the only in-house lawyer, so often it's firms who maybe aren't quite big enough or don't require enough services to actually engage someone to do it.
Yeah.
But in addition to that, we're also brought in to support existing legal to give a unit, more capacity, whether it's short or long term, and it might depend on projects. So a couple of the benefits of using Source are just fixed pricing, so it's a retained model. So it's the same amount every month. So there's cost certainty around that. And it can be anywhere. We have clients only paying $1,000 because they're very small, and clients paying upwards of 20,000 because they are massive. And it's a massively growing business, I have to say, because the model just works. People don't want to pay every 6 minutes. But anyway, that's what it's like. The other thing we offer is specialist skills. So as an in-house, if you had an in-house lawyer, you're likely to only really have one specialist set of skills and then another sort of jack of all trades skills behind that. Whereas with us, we actually have specialists. So I'm an employment lawyer, as Elizabeth said, but if I come across a workers' compensation question, more often than not, I can answer it, but sometimes it needs more specialist advice. And so at that point, I'll bring in one of my colleagues who's a specialist in that area. So you get access to all of that. The third big benefit is that it can scale up and scale down based on what your needs are. So if Fair Work come knocking at your door to say you've got potentially an underpayment claim, and you need to start checking through this, that, and the next thing, we can be there to actually just come in on a project, either deal with your existing business or actually deal with the new project as it happens. So it's, as I said, it's becoming very feasible. Anyway, moving on, let's get on to the topic.
Yeah, I was just going to say, if you don't have a general counsel or, a lawyer that's embedded in your business, and that's a very expensive person to have, obviously, then I can see the benefit of Source Services. Yeah.
Yeah, that's right. It depends. It is good for a lot of businesses. If you've got a massive legal team, then you probably don't need us.
Yeah. And what I'll do for everyone is when I send the recording, I'll send Helen-Anne's email, and if anyone wants to talk to her, you can just go to her directly.
Yes, no problem. I'm also happy to give you the slides to distribute if you want. And there's a lot of information in the slides because I think sometimes it's really difficult to try and take notes and listen at the same time. So you can have the slides.
Oh, great. Okay. I'm sure I certainly would love the slides. So I'll send for everyone who's here today, I'll send the slides. Yeah.
No worries, that's great. Right, so fixed term contracts, right. So what are the gist of the changes? This is a bit that probably most of you will be aware of. From today, employers are prevented from engaging an employee on a fixed term contract or multiple fixed term contracts for more than 2 years. They are also prevented from engaging someone on more than 2 rolling fixed term contracts, and that is regardless of the duration of each of those, right? So if you engage someone on a 3-month contract, and then that's renewed for a further 3 months, at the end of that 6 months, at the point where you're issuing them another contract, they are considered to be, well, you're actually not allowed to issue a further contract, but they are considered to be a permanent employee.
So you
the
give
maximum.
someone a fixed term contract for 3 months, then
Yep.
you roll it over and you give them another 3-month contract, that same person.
Yep.
And then after that 6 months, do you have to make them a permanent employee?
They are a permanent employee, yes. You're not allowed to extend it any more than 2 rolling contracts, whatever that duration is, or 2 years is the maximum.
Wow. Okay.
So
Okay.
now that's unless they fall under one of the exceptions in the Act. Okay,
And
so
you're going to tell us,
I'm going to tell you about that. Yeah. The other thing you need to know is that you must, and we'll come to this later on as well, is you must also provide a fixed term contract information sheet to each employee when they're signing up to be a fixed term employee. Sadly, I looked on the website earlier this morning and it's still not up. The fixed term contract information sheet is still not up. So you have to give them it at the earliest opportunity after they've commenced.
Okay.
So that's basically that.
And that's the Fair Work website, yeah?
It's the Fair Work Ombudsman or the Fair Work Authority. Yeah, they have it.
Yep.
So why have they done it? So why is that legislation come into play? So in essence, and these are just quotes taken out of the explanatory memorandum, and some other kind of information, but the current government considers that fixed term contracts are another form of insecure work, right? So they reckon anyone who's taken on a fixed term contract, they actually don't really want to be a fixed term contractor, and they're only taking that because they haven't got secure work, but they would actually much rather have secure work than what they consider insecure work, which is a fixed term contract. So that's basically it. It's very, very political. I think there's a lot of union pressure being applied as well. So there we go. So if we go to the next page, it's an employer, you can't enter into a contract of employment. And I know we're going over this again, but I think this is the crucial part of it. It cannot have a fixed term of more than 2 years. So 2 years is the absolute maximum. It cannot have a fixed term that can be extended or renewed. So the total period is more than 2 years. And it cannot have a right to extend or renew it more than once. So that's where the 2 3-month contracts come in. You can't do that.
So if someone's on a fixed term contract for 2 years, you then have to make them a permanent employee.
Yeah.
You can't renew the contract for another 2 years or
Nope.
3 months or whatever.
Nope.
And if you let that person go, you then 1 week later can't hire them again on a fixed term contract in the same job.
Yeah. Yeah, that's right. And we'll come to that later on as well. So there's a number of provisions, the anti-avoidance provisions, which stop you from doing things to prevent the new legislation applying.
Okay.
Right. So more specifically, limits on rolling fixed contracts. We've probably gone through some of this. If it has been, the other thing is if it's been in place, it will be unlawful to enter into another fixed term contract if the total period of the previous, that's what we said, and there've already been 2 fixed term contracts. The new contract has an option for renewal extension. A previous contract had an option for, I'm just reading over this, but you can read it yourselves. So yeah, that's just basically what we've been discussing between us.
Can I just ask? So
yeah.
if someone before today, because the legislation comes out today, before today, if you've got someone on a contract, it's still, and they've done a year, for example, it still applies to that person in another year's time, because it's then 2 years that have to be made permanent.
Yeah. So if you say their contract runs out on the 1st of January, their existing fixed term contract runs out on the 1st of January, and you renew their contract on the 1st of January, you can only renew that for 1 year. You can't renew it for 2 years.
So if you have someone,
the previous time counts.
Right. Yeah, that's what I thought, before today. Right. Yeah. And so you're saying that if they've done a year and it finishes on the 1st of January 2024, you can renew it for another year.
Yes, that's right.
But after that year, they have to be made permanent.
They're permanent employees. Yeah.
And if you let them go after the 2 years because you don't have the headcount, for example, do you have to give them a redundancy?
So not at the end of the 2 years, if that's within the 2-year period.
Okay.
So if it's the end of their contract, that's the end of their contract.
Right.
I mean, so this fixed term contract's still okay. It's only if it goes beyond that 2-year period or that subsequent period. So if you did if you gave them a 2-year contract, then you extended it by 6 months and then you paid them off, you would have to pay them notice and redundancy.
Right. Yeah, okay.
But if you actually exited them at the 2-year point, then there's no redundancy because your fixed term contract rules, your fixed term contract contractual entitlements under the contract, they apply. It's only when extended beyond that 2-year period that you would have to pay that redundancy notice.
And if you wanted to put someone else in that same role, if you had to let the person go because you didn't have the headcount after 2 years, and then you said, okay, well, we'll just put someone else in that job, what's the time frame before you can actually put someone else in the same job?
Yeah, they haven't. They've not outlined that. But I think what's clear is that if it was a 2-week holiday break, that wouldn't be sufficient. We know that and this comes up later on as well, but from the long service leave legislation, we know that it lasts, you're looking for a 3-month break. And for redundancy, well, that varies. There's no real rule, but for your long service leave, that tends to be the 3-month break, and that's what people tend to look at.
But you couldn't then, after 3 months, hire that same person who'd been doing the contract, or you could?
Well, 3 months is quite a chunky time. So there's no guidance on how long at this point, but I think 3 months is quite a significant time. So I think that might be sufficient to break the fact that it was avoidance. Do you know what I mean?
Yeah, I mean, obviously that person hopefully would have another job by then, you know what I mean? Unless they can, go on a holiday for 3 months, that would be nice. And then be rehired. And then would they be rehired on another 2-year fixed term contract, for example?
Yes.
Right.
Yeah.
Okay.
So you could, so the key thing about and I know this is coming up later on, so I'm going to be repeating myself, but I know that looking at what is a sufficient break, it's all about the anti-avoidance. If any of the reasons for the break, and this is what this slide here says, actually, there needs to be a sufficient connection between the contracts. So consecutive fixed term contracts will be allowed if the employee is not performing the same or substantially similar work that they were performing under the previous contract, and there's not substantial continuity of the employment relationship between the two contracts. So those are the two things you're looking for.
It's quite grey, isn't it? It's not black and white.
You're not going to know until the case law starts coming in essence. And even reading the explanatory memorandum, it's not giving you any specific information to get your teeth into. It's just very kind of vague. So this is here. It says employment could be continuous where an employee takes a short break for personal reasons, or the break is between semesters. Do you know what I mean? So you definitely have to look at what's the reason for the break. If the break is to prevent if any of the reasons for the break is to prevent the fixed term contract rules applying, then that's not allowed, and there'll be, there'll be disputes filed. So, and we come to that later as well, outlining what actually happens.
Okay.
Okay, right. Right. So types of contracts that are covered. So, and this is a key point as well. And I think I think you mentioned, Elizabeth, this was one of the questions that came through. What's the difference between a fixed term contract and a maximum term contract? For this legislation, nothing. Doesn't matter. But a max term contract in essence would usually be for a longer period of time. So you say you will be engaged for a maximum period of 2 years, but we're engaging you on that basis that you'll be provided with whatever it is, you'll be provided with like 3 or 4 weeks notice or whatever of the intention to terminate that max term contract. Do you know what I mean? So you'll be giving a notice period to them on a max term contract to say we can terminate any time up to that period, but that's the maximum term you're going to be engaged for.
Right.
So
yeah, because it's quite confusing. So a fixed term, so what you're saying is a maximum term contract. There's a period, a notice period that needs to apply in a contract, and it would say we'll give you 4 weeks notice or whatever. And with a fixed term contract, after the 2 years, it's like bye-bye.
Yeah, that's right. Although it's rare for a fixed term contract to have no notice in it, because then the contract has to run for that period.
Yeah, right.
So they're kind of merging together. Do you know what I mean? Your fixed term and your max term quite often kind of merge together in any event, because there's often a termination clause in a fixed term contract.
Right. So
yeah, but there's no difference from a legal perspective. There's no difference in how the rules apply. The 2 years is for a max term contract or a fixed term contract.
Okay.
Yeah.
Okay.
And the other thing that is very explicit as well is that the rules do not apply to casual employees, right? So a casual employee is someone who is paid a 25% loading on the rate to account for the fact that they're not being paid annual leave, sick leave, notice requirements, redundancy, etc. Right? So they're paid that 25% extra. They are not covered by any of this legislation. They are still governed by their own rules around how they are engaged. So your casual conversion and all that applies to only casual employees, and your fixed term rules, which is a maximum of 2 years. So 2 years does not apply to casual employees. Your max term and your fixed term contracts have the max term of 2 years.
Okay.
So there we go. Okay, next slide. Right, so what happens if you breach the rules? And what happens if you make a mistake and issue another contract as well? So unfortunately, the contract terms will stand. So the contract terms that you actually have put in place and that you've provided to people, if it's been extended or whatever, the terms and conditions contained within that will stand, with the exception of the end date. So whatever terms and conditions you put in, that's what applies. The employee will be classed as a permanent employee. So that means minimum notice of termination. And actually, it could potentially mean reasonable notice if it's not explicit enough. It also means redundancy pay, and it also introduces then unfair dismissal rights. So you need to consider that as well. Getting it wrong. Oh, sorry. Yeah.
Sorry, I was just going to say, what if you have someone and they're with you for because you know this what is going to happen, right? And you have someone and they do 1 year and 11 months, and then you let them go. That is really breaching the rules, isn't it?
Well, it depends on the reason why you're letting them go, because you've obviously issued a fixed term contract for 2 years, so it might be completely reasonable to let them go at 2 years. So if it's to avoid the
making them
application of the new laws, then that would be not allowed. But if you genuinely don't have a need for that role anymore at 1 year and 11 months, or even at 2 years, if you don't have a need for that role anymore, then it's a fixed term contract and it goes in accordance with the rules of the
Yeah,
contractual
I
requirement.
was just thinking of, you've got that avoidance, of oh, we have to make this person permanent after 2 years. So at 1 year and 11 months, we let them go because we don't want to make them permanent at 2 years. Yeah, that's obviously avoidance, and that's not allowed, right?
Yeah. If you're doing it purely to avoid the rules, then yeah, you can't you can't really do that. But in terms of looking at the rules, not that I'm suggesting this is a good plan, but in terms of looking at the rules, the closer you get to the 2 years before you exit someone, the more likely it is to raise questions around whether it's actually anti-avoidance.
And,
Do you know what I mean?
and the employee of a fixed term contract could potentially go to Fair Work and say, I was dismissed because of this reason.
Yeah. So it's a general protections claim. And then it can be escalated to the court as well. However, back to the slide again, but if you get it wrong, it's very costly. Civil penalties, maximum fine 93,900 for a corporation just now, and also 18,780 for individuals. So it's a hefty fine if you get it wrong. Now, we've no idea as to when these kind of fines are going to be applicable, but if you look at the past, they haven't, generally Fair Work don't hit you with a civil penalty unless it's a very clear and obvious breach and it's intentional. Do you know what I mean? But that's not to say that it's not going to they're not going to use it for any other reason.
And I heard that if the salary is over 167,500, so 167,500 as a salary, above that, this doesn't count.
Yes, so that's one of the exceptions. So if we go on to the next slide,
Okay,
that's
sorry.
actually the exceptions.
Yep,
No, you could. What are the exceptions? This is likely to be where your case law is going to materialize. So the exceptions include specialized skills for a specific task. So for example, that's in there. The example, employer specialized skills employer does not have but needs to complete a specific task. That doesn't really tell you particularly much.
No.
But thankfully, they've actually provided some other examples which are good. So if you had a technology professional who's engaged to provide specialized technology support on a particular project, the contract's for a period of 6 months, but you might have 3 options to extend for 1 month each time on account of delays, then that's allowed. Do you know what I mean? So it might be, so you might have someone building a road and the project's supposed to go for, for 12 months, their part of the project goes for 12 months, but that runs over and you therefore have to extend twice to get the job finished for that specialized task. That's allowed. Okay, so that's classed as an exception. So you might have a training arrangement. So any formal training arrangement has to be made under a state or territory law. So it might combine with what's likely to combine with sort of study for a qualification such as an apprentice. So as an example, you might have someone who's engaged in a 4-year fixed term contract for the duration, and if it's for the duration of the apprenticeship and the apprenticeship ends at the end of 4 years, then that will be allowed. Okay, so that's an exception that's allowed. Essential work is another one. So someone's performing essential work during a peak kind of demand period. And as an example, it might be, for example, a ski patroller with first aid skills, and the ski resort hires them on a 2-month contract, but during the ski season, but you never know what the snow is going to look like. So, if depending on the conditions, that contract might be allowed to be extended twice or 3 times. Do you know what I mean? So that's allowed.
Yeah.
The other one is emergency circumstances. So what would that be? So it might be someone who's temporarily away. So if someone takes maternity leave for 24 months, and that person's going to be away for 24 months, paternity leave or maternity leave, parental leave, during that time, person has another child, and they're then entitled to take an additional 12 months off. The fixed term contract can be renewed for another 12 months to take account of the fact that they're covering that leave period. Now, you wouldn't, for me, I wouldn't look at that and think, well, that must be emergency circumstances. But you can 100% understand why, that it's allowed. Maybe not why it's called emergency, but I get, why you would allow that to happen and why you'd allow that exception to apply.
It's just so grey. Like, it's just so grey. Like, you really need to talk to someone about, this is my situation, what do we do about it? Because the government, it's to me anyway, it's not overly clear.
It's just we're going to have to suck it and see in terms of what happens and what cases come out of it. And I'm sure there'll be quite a few, and there'll be a lot of people who will object to exceptions that have been, where the contract has been renewed again, a fixed term contract been renewed, and they'd rather be a permanent employee. Although I have to say, there's a lot of people who really want to stay on the fixed term contracts and are very upset that this legislation's coming at all.
Yeah.
Anyway, never mind.
Because they don't want to be permanent. They don't want to be permanent. Right. Yeah.
That's right. So one of the other, this is the one you were mentioning earlier about the high income threshold. So if for example you've got a project manager who earns $240,000 or $200,000 a year, even if it's $200,000, actually let's even bring it lower. Even if you say they're engaged on $170,000 a year, which is very close to the cap, on a 3-year fixed term contract, that's above the high income threshold. Now, the definitive time was it above the high income threshold at the time when the contract was entered into. So that covers the 3 years. Even though the high income threshold goes up every year on the 1st of July by a certain percentage, even if that high income threshold goes above the level that you agreed to pay at the first, it's the first year that counts. So if they're above it at the point where they enter into the contract, then that's allowed as an exception. Fixed terms printed under applicable award or regulations. So that is that what I've got to? Yeah. So they are applicable. The applicable award or regulations. Some awards actually do allow for an employee to negotiate with an employer on a fixed term basis for multiple times, for multiple years. So if it's allowed in your award, then that's fine. There's also government funding. Government funding is another one, because there's a lot of people who are actually doing government contracts just now, and a lot of them are actually being reduced as well, I think. If you've got someone, for example, who's engaged in a 3-year fixed term contract to work on creating a community garden for a community organisation, that project's fully funded over that 3-year period by a local government. And so the funding will end at the end of that, but that's allowed because it's purely government funded. The guidelines explain, though, that the government funding has to be unlikely to be renewed after. So it's not the same as working for a government agency or a department on a fixed term basis. They're different. It's very clearly about the funding and whether it's reasonable. It's reasonably expected that funding is not going to be available at the end of the period. So it's not just about working for government on a fixed term contract. It's about specifically getting approval for funding and it not being expected to continue beyond the 2 years. So that's one. The governance is another exception. And that's usually based on the rules of a corporation or an association. So a person might be engaged in a 5-year contract on the executive board of a land council or something. So that's where that one comes in. And that's it. Now, there were also some new exemptions that came in at the end of November 2023. So just at the end of November, they introduced some new ones, permitting further exceptions. And those relate to organised sport, high performance sport, live performance, higher education, positions funded by philanthropic entities or testamentary gifts or contributions, etc. So those exceptions commence, and this is really actually I find it quite bizarre, but these exceptions commence along with the other provisions on the 6th of December. But unlike the other exceptions, those within the regulations will only apply to contracts entered into on or after the 6th of December and before the 1st of July 2024. So there's like a 7-month period there where you can have an exception in relation to those specific areas. Now, these are going to have they're very limited. Obviously, they're limited in terms of where they actually are, and their impact is going to be very specific to people within those areas.
Yeah.
And it's also very bizarre that it's very temporary. So I don't know if maybe they're considering something else to happen, and they're going to give themselves some time to do something with them. I'm not sure. But that's what it says. 7 months. You've got an exception there in those areas.
Okay.
That's that. So now, a couple of things to note. The employer bears the onus of proving that the exception they rely on applies. And in the explanatory memorandum, it actually suggests quite strongly, well, I mean, it's mentioned in there anyway, so the exception that you're relying on should be inserted into the terms of the contract, and the basis on which they consider the exception applies. So that assists the employer in meeting the burden. So if you think you've got an exception there as to why a fixed term contract can apply, even if it's because they're above the high income threshold, you should really be putting in a sentence there saying, so all your contracts are going to have to change. You just need to get a sentence in there that says that we consider, having considered the exceptions to the application, we consider this person is above the high income threshold in the year 2023, 2024 when the fixed term contract commenced, and therefore it's an exception to these applications. Well, maybe not word it that way, but you definitely put something in which shows that you've considered, and you're explaining not only to a court if it comes to that, or to the commission, but you're also explaining to the person at the point where they are signing the contract that they're an exception and they're not going to be called a permanent employee. So, just a reminder of the purpose. It's all about job security, and it's all about insecure work. So that's basically why it's been introduced. And obviously there's other new rules coming in around casuals probably at the start of next year as well. But just now, fixed term contracts. Timing issues, contracts entered into before 6th of December aren't covered. So yesterday, if you entered into a 3-year deal with someone, a fixed term contract with someone, you could have done that. You could have a 3-year contract yesterday. You could have a contract lasting as long as your commercial contract lasts with the supplier or anyone else. However, from today, you need to restrict your contracts to that shorter period.
But sorry, Helen-Anne, can I just ask a question? So when I said before, if the person started like in May this year and they're on a 2-year fixed term contract, after the 2 years, they still have to be made permanent? Or you're saying that because they entered into the contract before today, they're okay, they can just continue on?
So if you renew it in May, the time prior will count.
Won't count.
Will count.
Right. So if you renew it in May after a year and then they do a 2-year contract, that's okay?
No, because the time prior counts.
Right.
So they've already had a year. You can only renew it for a year.
Right. Right. So that's what you're saying here. Contracts entered into before today won't be covered.
Yeah. So you could have yesterday, you could have signed a contract for 3 years, and that's fine. That's not a problem. That's not a breach of the rules. Unless you were only doing that to actually avoid the requirements. But it's reasonably easy to. I'm suggesting it would be reasonably easy to say that's not anti-avoidance. That was just you needing to get a contract out. But from today, you can't do that. So if the person's contract is up for renewal in May and they've already had 1 year, you can only really sign them up for another year as a fixed term contractor. And when it comes for a renewal the following May, then they're going to be classed as a permanent employee.
Okay.
So yeah, so that's it. The previous term, if you renew after the 6th of December, so after today, then any previous term will count towards a 2-year limitation, even if it was in place before the 6th of December.
Right. Okay. Okay.
So, anti-avoidance measures, here we are. We've already actually gone through most of these, but so you can't do any of the following to avoid the new rule. You cannot terminate an employee's employment for a period. A 2-week period is not going to cut it. We've already talked about that. And I guess if we look at the long service leave provisions, as I was saying, the 3 months seems to be enough to cut that. And I would suggest that 3 months would certainly be enough. I would hope it would be enough to cut into any continuity of employment in that regard. It's likely, I mean, I'm sure they're likely to fall on a shorter period, but I wouldn't like to give any guidance on that at all just now. Delaying or re-engaging the employee for a period. So again, it's looking at a break. Why are you delaying? Again, this comes back to a 2-week period. Not re-engaging an employee and instead engaging another employee to provide the same or substantially similar work. Can't do that. You can't change.
Sorry, just on that one.
Yeah.
So you after 2 years, you don't have a head count, the person leaves, and then you can't re-engage someone else to do that same job. But are you saying, I think you said before, and maybe I've got this wrong, but there's a 3-month period where if you wait 3 months, you can then put someone else in that job?
Well, that's my interpretation. That's not what the rules, they don't give us any guidance about what the time is. So what I'm doing is I'm looking at other pieces of legislation where it's considered there is a break. So if you look at the long service leave provisions, they say that 3 months is sufficient break to break continuity of service for long service leave. And I can't see why. I mean, a 3-month period is a quarter of a year. Do you know what I mean? It's quite a substantial period. So what I'm saying is that seems like, in my mind, I don't see why you wouldn't be able to engage someone else to perform a job after a period of time like that. Do you know what I mean? It's all looking at how long is a piece of string. We're kind of guessing at what that period might be. Right. And it may well be a shorter period.
Okay, but right now we don't know right now.
Don't know.
Right.
So you're not allowed to re-engage someone instead of that employee to provide the same or substantially similar work. You're not allowed to change the nature of the work or task that the employee is required to perform. So not in a minor way. If it's a completely different job, different project, then yes, you can. Do you know what I mean? So if someone's working on building a road over here, and then instead they're off to do some project management and a different task over here, then that's not the same or even substantially similar. They're completely different contracts. That's you just trying to utilise a person you found that's quite good.
Right. So you can have someone for 2 years and then you can say, oh, we think you're really good. And so how about we put you over they're in like sales, for example, or, regulatory affairs. And then we need someone over in quality assurance because, well, it's a little bit similar, but you could do that.
Yeah, as long as it's not anti-avoidance.
Yeah, as long as it's not to avoid hiring them on a permanent basis.
Yes, that's exactly right. And so some employers will consider whether they could change, instead of them working specifically dealing with this client and that client, they're actually going to change them to be working with this client and that client, but still doing the same job. For example, if they're an IT company looking after this, that, or the next thing, that probably would be substantially similar work. It's just the same work, but working for different clients. Do you know what I mean? So if there's minor tweaks to a role, that's not going to cut it.
Yeah.
That probably would be seen as anti-avoidance.
Okay.
Again, that's just my interpretation of what that would look like. And that's the change in the nature of the work. And the other question I've got in here, which is in relation to altering the employment relationship. So how do you do that? So there was definitely, we had a query where someone came in as to whether they could, you could engage them for 2 years and then perhaps use a labour hire provider to engage them for 2 years. And so we've had a discussion about this internally as to whether that's, because from an immigration point of view, that causes real difficulties. Now, the laws are not the same, definitely not the same in terms of, having someone on a 6 months they can work here and 6 months they can work here. But we don't actually think that's going to cut it. We think that's likely to be altering the employment relationship because they're still essentially performing the same job.
So if they were working with a company for 2 years, and then because you didn't want to make them permanent, you put that person, you said to a recruitment agency, can you take this person on your books as your employee for the next 2 years? That probably isn't going to work.
That's probably not going to work. Someone's going to make that claim that it was anti-avoidance and it was to prevent them being considered a permanent employee.
And what if the other way, they're working for an agency for 2 years and then the client wants to take them direct and pay them direct for 2 years? That's the same thing. That probably won't work either.
Yeah, it's probably the same job. Yeah.
Right.
Yeah, if it's substantially the same job. And well, I mean, people do actually do that, but it's just altering the employment relationship, isn't it? That the host employer at that point should be taking them on as a permanent employee because they've already benefited from the use of the employee for the last 2 years.
Yeah, right.
So, again, it's going to come down to facts. If there's any hint of avoidance of the need to convert them to a permanent employee, then yeah, you're going to lose that battle. It's a battle you're not going to win.
Okay.
So the other thing I was saying, if you know how with casual employees you have a 25% loading,
yeah,
and you pay them at 25% loading on account of the fact they have insecure work.
Yeah.
Now I can't see anything that would prevent you from doing that for a fixed term contract. So if you're paying above, unless providing you're paying above award. But you might be paying someone a fixed term rate. I can't see any reason why you wouldn't be able to introduce an insecure loading of 10% and include that, or whatever percentage, and include that in the amount that they're actually being paid. And then at the point where they're made a permanent employee, they would actually lose that loading. But at the very least, you would have the opportunity to negotiate. So you might find that somebody would resign, at which point you can then negotiate to put them back up if you want to keep them as a permanent employee. But it also then allows you to start accruing, from that for any redundancy, any notice requirements, etc., that need to be paid. And I can't see that you wouldn't be able to do that, is introduce an insecure loading for anybody who's on a fixed term contract. Then when they become a permanent, that can be reduced because that's fair and everybody's aware of it.
Yeah. So if you had like a temp casual, and they're being paid a loading, but they're not being given permanent employee benefits such as sick leave, annual leave, etc., and that's why they get the loading, you could probably keep that person for more than 2 years. Is that what you're saying?
No.
Okay.
No, what I'm saying is,
sorry.
No. So yeah, your casual employees don't get their annual leave, their sick leave, and etc.
Yeah.
Fixed term contractors do get annual leave and sick leave, but they don't get notice and they don't get redundancy because it's a short term duration contract.
Yeah.
So, but what I'm saying is you can introduce a loading to how much they're actually being paid. So if say you're paying them $10,000 a month, you can say, 10% of that $10,000 you're getting paid per month is actually an insecure loading. So your actual wages are only 9,000 plus the 1,000 because it's a fixed term contract, because it's insecure work. But please note that, if your role subsequently becomes a permanent employee, you will lose that insecure work loading. So what that means is at the end of the period, say it's 12 months, or even 24 months, at the 24-month period, you're saying to them, right, okay, this is where we are now. We can now make you a permanent employee, but you will lose that 10% insecure, because now you've got certainty in your role. You're no longer insecure according to the laws. So your salary is going to drop to $9,000 a month.
Yeah.
Now the employee can then say, well, no, I'm not accepting that. I'm going to resign. At which point you're then in a stronger position, because you can say, well, okay, well, if we want to keep them as a permanent employee, let's negotiate that. And if they say, if the person says, okay, well, I'll accept the $9,000, that's fine, then you've got $1,000 to use, do you know what I mean, additional to use per month, for the new accruals that you've got to go anyway. You've got to use.
Right. Right. So basically the whole crux of this law is to help people not have insecure work. That's the whole reason behind it, isn't it?
Yes.
Yeah. So the government's saying it's not fair if employees just keep people on contracts, when people should be getting a permanent job after working with an employer for 2 years. So we're going to introduce this new law so people it can be made permanent after a 2-year period, so they don't have job insecurity.
Yeah.
Right. Okay. We've got some questions, Helen-Anne. Is that okay?
No worries. Yeah. I think I'd. Yeah, that's it. The statement's yet to be published. What should I do now? These are the things. If I can just clear our way up to.
Yeah.
Right, we're okay. So these are the things that we need to be doing now. Renew any arrangements that expire before the 6th of December. We'll probably kind of miss that.
Which is today, yeah.
Yeah. Start planning for any that will come up for renewal after the 6th of December. Review your contract templates to ensure there's no unlawful terms. So we don't want these renewals in there, those automatic or renewals, or the ability to renew the contract indefinitely or twice or whatever. Work out whether any of the exceptions apply, and if they do apply, make sure they go into the contracts that you're providing to people, because that's your onus of proof, and it's you notifying the employee that they're not going to get permanency at the end of the fixed term contract.
Right.
You need to train your hiring managers who use fixed term contracts that's what needs to be done. And you need to build your fixed term contract information statement into the contract process, which is really interesting, seeing as we don't have it yet.
So when will that be on the Fair Work website? Well, is that where
you were hoping? I was hoping it would be up today, but it just wasn't up when I looked at it earlier. So maybe up now, I'm not sure.
Okay.
But the other thing is there's a huge debate as to how this has got to be provided, because the regulations only say it's got to be given to them. But given to them how? And there's no ability to introduce regulations to stipulate how it's to be given to them. So I'm thinking it'll be okay, again, putting into a link in a contract, which is what you do with a Fair Work information statement, not the fixed term one. But it may well be that you actually need to give them a copy or email them a copy, and hopefully you don't need to get authority to do that.
Yeah. Okay, so that's something that we need to be aware of, that fixed term information sheet, which is currently not on the Fair Work website, but we're hoping it will come up. Okay, fantastic. Thank you, Helen-Anne. That was excellent. I'm still a little bit confused, and we've got some questions.
About that.
No, it's not your fault. Okay, so we have someone who said, if you hire someone on a 2-year contract, the contract ends, and you hire someone else on a 2-year contract, this would be unlawful. Yeah. So assume
only if it's the same job.
Yeah, it's the same job. Yeah. To avoid making the role permanent. Yes. So we've answered that. So yes, it's unlawful. We can't do that. So Steve says a lot of discussion re the 2-year time frame. Does the conversion to permanent occur after one extension, regardless of time? example, 3 months gets extended by another 3 months, but then I presume you cannot extend another 3 months, but instead the permanent status comes into effect after 6 months in this case. I think that's right, isn't it? That's what you said.
Yeah, that's right.
Yeah.
And
Okay.
you'd really want to be issuing a permanent contract.
Yeah.
Well,
yeah.
you should be issuing a permanent contract. Do you know what I mean? That's exactly what you should be doing, because you don't want to issue another fixed term, because that's unlawful.
Well, what's the full name of the new legislation?
It's the Same Job, Same Pay Act, actually.
Same Job, Same Pay Act.
Yeah.
And that's the name of the legislation, yeah?
Yeah.
Okay. Now, someone who is hired as a contractor under an ABN, this does not apply.
No, ABN's not apply. So, but what I would say is to make sure, again, there's all these other rules coming in around the ABNs. Make sure they have an ACN, and make sure they have all of the insurances that you require, because it's becoming less and less beneficial to actually hire just an ABN who doesn't have an ACN and doesn't have all insurances, because they'll be caught under your workers' comp insurance.
Yeah, that's right. That's right. So yeah, they've got to have their own workers' comp, etc. Okay. From Evelina, I heard the government was going to issue an information sheet that must be given to all fixed-term employees. Do you know when that will be available? I think we just said we don't know when that will be available.
Yeah.
Fair Work website, I would just keep checking on that and to see when that's coming. As Helen-Anne said, she looked this morning and it's not there yet. So we don't know, Helen-Anne, do we?
No, don't know.
Okay. And then Evelina
the good thing is the regulations stipulate that you have to give it to them at commencement of their fixed term contract, or as soon as possible thereafter.
Okay. And also, are there still discussions happening as to whether there will be a visa exemption category?
Yeah, I don't know. I'd heard that there were, and then these exceptions obviously came out at the end of November and they're not in there. So it's very tricky. But I think for those situations, what you must do is make sure your contracts contain a relevant term that says if you lose the right to work in Australia, your contract will be terminated immediately. Okay, so you don't want to be given notice. So you need to make sure there's no notice. If they lose the right to work in Australia, they immediately lose their job.
Yeah, which makes sense. Yeah.
Yeah. So even if they're a perm, they just immediately lose it because they can't work.
Right. Okay. I've just heard that the statement is up on the Fair Work site now.
Oh, good. Good.
So yeah, so you can have, if you go to the Fair Work site, the statement is now up. Someone has just told me that. I'll send everyone the link to that along with the slides. And Richard says, can you offer a contract to the same employee for a different role beyond the second contract or 2 years? And I think we've answered that one. If it's a similar role, no. But if it's a completely different role and you want to keep the person, you can. Is that right, Helen-Anne?
Yeah, I think that's pretty fair. Yeah, as long as you're not exiting them from the old role to avoid the provisions, to avoid making them a permanent contract. So it's all about the intention. So if there's the slightest hint that the only reason you're moving them out of that role into another role is to avoid making them a permanent employee, then that's still anti-avoidance.
Okay.
So you need to be careful about what you're doing. Yeah.
And Steve says, can you please explain again the difference between an individual on a fixed term contract versus someone with their own ABN on a fixed term contract?
So your ABN holders have their own company. So they're actually not providing labor, they're providing services.
Right.
And again, because of the new closing the loopholes legislation, I know it's only in draft just now, that's likely to come in next year. You have to be very careful about what's actually going back into your contracts for your ABN contractors again. So it has to be the performance of services as opposed to a contract for labor. So, you know, what services are they actually providing? Are they being paid in milestone payments? It might be for a fixed specific term, might be for a 2-year term. or it might be for a 3-year term. But it has to be, it has to be, yeah, it's hard to say, but it's for a contract, it's for contract for services, not for a contract for labor. So you're not paying them hourly, you should be paying them like milestone payments.
Or you
But
could
when they
pay them like a daily rate. I mean, they charge like, I don't know, $2,000 a day, and then you pay them a daily rate.
yeah,
As
so
long
you're
as
paying them
they,
the rate, yeah.
as
They're
long,
not caught. The ABNs are not caught. You're paying them a daily rate. You're paying them not paying them tax. You're not paying tax, so no PAYG tax.
that's right.
Etc. etc. But
Yeah,
just make sure that they have that ACN and not an ABN and a sole trader, because the sole traders are going to be dragged into it as well, I think.
Yeah, so not sole trader. So we're talking about someone with their own ACN, and then they have to pay their own tax, obviously, and their own insurances, i.e., such as workers' comp. Yeah.
Yeah.
Okay. And then Rishika says, I have a question around converting a full-time employee after 2 years of tenure to convert as casual employee on agency's payroll. Does it come under altering the employment relationship? I think we covered that. That yes, if they're employed by a company for 2 years and then you put them on the payroll of a agency, that is altering the employment relationship. Helen-Anne, have I got that right?
If it's for another reason, if it's not, I mean, there's various things you can do around people's employment as long as it's not for the reason of avoiding the new laws.
Yeah.
Okay,
So
then it becomes unlawful. So
yeah,
whatever changes you're making have to be not to avoid making that person a permanent employee. And pushing someone to a labour hire agency who's on a fixed term contract on a casual basis immediately would raise warning bells.
yeah,
I would
yeah.
say.
Like why wouldn't you be making that person a permanent employee?
Well,
Why
why are you transferring them?
why are you
Why would you
transferring
do
them
it?
to an agency's payroll? Yeah, that
Yeah.
would raise red flags, Richika. So I think you'd need to really look at that. All right, I think we've answered we had 10 questions, we've done that. I'll send everyone the slides and the Fair Work link. And I'm very, very grateful, Helen-Anne, for your time today. I'll send everyone Helen-Anne's details. If you want to speak to her, you can, obviously. And if anyone wants to chat to me, just give me a call, and you'll have all my details on my email signature, because I've sent the invite via email to everyone. Thank you, Helen-Anne. It was really, really, really good, even though, as I said, I'm still a bit confused because there's a lot of grey areas with government and legislation, as there is always. But I think that this does help us to understand what gives us some
Gives you something to think about.
information to think about, and then I think we're all clear on the 2-year thing and what you need to do in making that person permanent or whatever.
Yeah, no worries at all.
All right.
Listen, everybody, I can't see who's on the call, but have a great Christmas and a great
Yes.
New Year. Celebrate
Yes.
hard.
Merry Christmas, everybody. Thanks, Helen-Anne.
Thank you.
Bye.
Bye.
Bye. Bye. Bye.
Bye-bye.
Bye.